Aloha and welcome to Hana Kakou. We're a weekly program on the ThinkTech Hawaii Broadcast Network. I'm Keli'i Akina, president of the Goldwater Institute. One of the great resources that the Goldwater Institute avails itself of is that we're part of a nationwide network of similar think tanks in all of the 50 states. And today we're going to talk with a couple members of the Goldwater Institute who are working very hard on the mainland to fight against something that might seem remote to us in Hawaii, but could have a bearing upon the future for us and for our children. It's the Indian Child Welfare Act. Unknown to many people in our country, there are two sets of laws, it seems, one for everybody and then one for Native American children. And this creates a tremendous disparity in the way kids are treated, and it's something that is not only tragic but unjust. I'm grateful that we have today with us Goldwater lawyers who are going to talk a little bit about this happening in the mainland, and we'll be able to look at whether or not it's something that we would ever want to come to Hawaii. I know that there are a good number of people who are talking about trying to get Native Hawaiians recognized as an Indian tribe. They may want to think twice after seeing today's episode. Before we move on, I want to say thanks to ThinkTech Hawaii producer Jay Fidel, who has encouraged me to produce occasional commentaries, and one will be following in just a moment. We have been looking at tremendously interesting happenings regarding the Native Hawaiian people and the greater population. If you'll take a moment, I'd like to share my thoughts on that at this time. If the studio would kindly play our commentary for the day, that'll be great. Aloha, this is Keli'i Akina with the Goldwater Institute. Recently, 4 Native Hawaiians and 2 non-Hawaiians filed suit in federal court to stop the Office of Hawaiian Affairs and the Native Hawaiian Roll Commission from conducting a race-based election to create a racially exclusive nation of Native Hawaiians. The suit finally gives voice to the silent majority of Native Hawaiians who have chosen not to take part in this racially divisive government-sponsored process. How do we know the majority of Native Hawaiians do not share the vision that a small group of government officials have called or crafted? The numbers speak for themselves. After spending 3 years and over $4 million to create a list of Native Hawaiians who, quote, affirm the unrelinquished sovereignty of the Native Hawaiian people, end quote, more than 84% of all Native Hawaiians remain unregistered. The Commission originally targeted more than 500,000 Native Hawaiians across the country based on U.S. Census data, which now counts 560,000. When only 40,000 signed up, the Roll Commission then dumped 87,000 names of individuals collected from other lists of Hawaiians without the consent of those individuals. Currently, the Commission reports it has certified 95,000 names on the roll. There are 3 problems the silent majority of Native Hawaiians have with OHA and the Roll Commission. First, many individuals who have discovered that their names were put on the roll without their consent are angered. One Native Hawaiian woman puts it this way, quote, "I saw my name on the list, and that's when I knew they're not totally honest," end quote. A Maui man living on Hawaiian homestead land says, quote, "When I found out that my name was on that list, it made me feel very uncomfortable in what they're doing and what they're trying to portray. When you start off doing things without people's consent, it's not right," end quote. Another woman has reported, quote, "I feel betrayed." The second problem that many Native Hawaiians, including myself, have with the process is being excluded for not affirming the Declaration of Unrelinquished Sovereignty. Like my father and uncle, who are buried respectively at Kaneohe and Punchbowl Military Veterans Cemeteries, we are Hawaiians who cherish and are proud of our American citizenship. The third problem for many Native Hawaiians is the total exclusion of non-Hawaiians from decisions that will affect everyone in the state. This is not only unconstitutional behavior by our state agencies, OHA and the Native Hawaiian Roll, it is blatantly non-Hawaiian. Hawaiian citizenship, even before we were part of the United States, was never based upon race. The silent majority of Native Hawaiians practice inclusiveness as part of the Aloha spirit. We seek to live by the words of the 1840 Constitution of the Hawaiian Kingdom that welcomes all, stating, "God hath made of one blood, Koko, all nations of men to dwell on the earth in unity and blessedness." Today, there's a growing stereotype of Native Hawaiians as a monolithic group that opposes all that is American and asserts exclusive rights against the majority of others who have made Hawaii their home. This stereotype is clearly not the true picture. The silent majority of Native Hawaiians are also of Japanese, Chinese, Caucasian, Filipino, and countless other racial backgrounds. All of us in Hawaii are the reason Martin Luther King and hundreds of marchers wore garlands of lei during the famous March in Selma. King visited our islands in 1959 and addressed both houses of our newly formed state legislature, telling them, quote, "As I think of the struggle that we are engaged in the Southland, we look to you, Hawaii, for inspiration as a noble example where you have already accomplished in the area of racial harmony and racial justice what we are struggling to accomplish in other sections of the country. The silent majority of Native Hawaiians want a future where King's dream is realized by everyone's keiki." I'm Keli'i Akina, president of the Goldwater Institute. Aloha, we're back live now with a Hana Kakou, a very special program today, Equal Protection for Indian Children. Something relevant not only to Native American Indian children, but potentially to young men and women, children here in the state of Hawaii. My guests today are with the Goldwater Institute, a venerable think tank that is committed to individual liberty, free markets, limited accountable government, doing tremendous work, distinguished nationally. My guests include Vice President of the Institute, Christina Sandefur. Welcome, Christina, to the program. Aloha to you.
Aloha.
Good to have you on board. And also, Dynar, one of their attorneys. Aloha, Adi.
Aloha.
Great. You know, we have something in common because we're part of a national network together. And so when we get together and party, we talk about issues like federalism. Isn't that right?
That's correct. Yes, we party only like nerds do, right?
And you know, that's an interesting word, probably a good one to kind of help people understand what we do in the think tank world. Christina, what do you see federalism as being? We remember James Madison and the Federalist Papers back a couple hundred plus years ago. Today, I think the word federal almost always invokes the big government from Washington, D.C., but this concept is quite different, isn't it?
That's right. You know, it's a really good question, and the words of our founders really are still very relevant today, if not more so than when they were written over 200 years ago. Our founders designed a system of government for us that was a dual system of government. So they broke down the division of power. We have a federal government, but we also have state governments. So at the Goldwater Institute, we like to say that we protect liberty from coast to coast using both the federal constitutions, but also the constitutions of the 50 states. And the reason that our founders did this is that this provides a dual layer of security for the people. So in other words, our government is supposed to protect our rights, but sometimes we have to worry about who's protecting us from government. When you give government power, it can be very dangerous. And so that's why if the federal government overreaches, then the state government can step in and push back against that federal power.
Well, Adi, what are some of the things that Goldwater Institute has done to help prevent the encroachment upon the states by the federal government? I know that there have been many celebrated cases that Goldwater has effectively tried.
Well, one of the biggest cases we have dealt with is the Medicaid expansion case. We have also dealt with taking the Affordable Care Act head on in a federal challenge. We have also used state constitutions to push back on federal government. Our lawsuit in the city of Tombstone tried to push back federal encroachment on cities and states when they are using their legitimate police powers to provide for water for their residents.
Well, you know, the work that you're doing is so very important, but I have to confess to you that it would sound strange to many people here in the state of Hawaii. We tend to look to the federal government as being the source of the money that we need, of the military that brings a boost to our economy, of funding for our schools and for our big public works projects like the fixed rail system and so forth. So we measure our politicians by how much more money they can get from the federal government, which always comes with a measure of control. Christina, what are some of the distinctives that Goldwater Institute stands for?
Well, our friend and one of my personal heroes, George Will, describes the Goldwater Institute this way. He says, the Goldwater Institute is in the liberty business. And that's exactly how I think of us. We are in the business of working in courtrooms and capitals and in communities across the country to really defend and advance individual freedom for people in all of the 50 states. And so we look toward free enterprise, allowing people to pursue the right to earn a living and to pursue a legitimate business. We look for people to be able to, we protect people's freedoms against federal overreach when, say in the case where a patient is terminally ill and has tried all options and really needs a medicine that's already been proven safe, but just has not been fully approved for market by the FDA. We want to protect that patient's right to try to save his life. Things like that, things that really impact individuals.
Well, you play a very important role. When we come back from a short break, I'm going to ask Adi to talk a little bit about Goldwater as a public interest law firm and what really that means in terms of applying constitutional law to protecting the balance of power between the government at the federal level and the state. I'm Keli'i Akina, and you're watching Hana Kakou. Please don't go away. When we come back, we're going to be talking about the Equal Protection for Indian Children, the Indian Child Welfare Act, and you'll find some fascinating insights from our guests. We'll be right back after this short message.
Hi, I'm Jay Fidel. I'm host of Hawaii, the State of Clean Energy, which is our flagship show, which plays 4 to 5 p.m. every Wednesday. And the supporters of that show are Hawaii Energy Policy Forum and Hawaii Energy. And luckily enough, we have representatives of both of them right here today to tell you more about what they think about the show. Sharon Moriwaki at my left is co-chair of Hawaii Energy Policy Forum, and she goes first. Sharon?
Thank you. Thank you, Jay. I'm so glad that we have this Hawaii, the State of Clean Energy. This was 2 years ago when we started this, and we have continued it because it's so important, and there's so many developments happening across the state, and we hope you'll tune in every Wednesday, 4 to 5. It's wonderful.
And Ray is Hawaii Energy. Ray, what is your thought about the same subject?
Well, I agree completely with Sharon that we are talking about every Wednesday, 4 to 5. We talk about some of the most important subjects that are affecting the islands now and into the future. Energy, clean energy, we need it. We often run into new ideas that we had not thought about before. We did just today, and I think we're going to have more of that in the future. So come on down and watch us 4 to 5 on Wednesdays, and we'll see what happens.
We'll see you then. Aloha.
Aloha.
Welcome back to Hana Kakou. We're here every week on the ThinkTech Hawaii Broadcast Network. Hana Kakou. Where does that phrase come from? At the Goldwater Institute, we like to say something that sounds like a venerable old Hawaiian saying, e pule kako, which means let's pray together. But we also say, e Hana Kakou, let's work together. Let's unite Hawaii's people to work for a better government, economy, and society. Well, I know Goldwater Institute is doing that on a national level, so I'm so proud to be part of the same network, state policy network of think tanks. Christina Sandefur and Adi Dynar are with me again today, talking a bit about their work. Adi, you and Christina are attorneys, and to some extent, the Goldwater Institute is a public interest law firm. Tell me a little bit about that, the use of the law in order to accomplish good public policy.
I think one of the things that law does for each and every one of us is to protect our individual rights. And I think that is one of the most important things that is missing from the political landscape, from the litigation landscape. And that's where the Goldwater Institute steps in to litigate, to protect individual rights, to protect individual freedoms. We use tools that are part of the Constitution, like federalism. We try to use the state constitutions and the federal Constitution to push back on non-legitimate government, because individual rights protection is really an important purpose that is often overlooked in litigation, and that's what we do.
Yes, there's certainly the political avenue that we seek recourse to in order to change what is going on in government when it's not ideal. But it is very heartening that we do have the Constitution of the United States and we can use the courts when necessary. In fact, Christina, you've been with Goldwater for a while and you've been in the think tank world for a while. What are some of the broader issues that you are able to address as a well-equipped legal think tank?
Well, one of the great things about the Goldwater Institute that that I was not able to experience at other places is that we do everything in-house. So in other words, we will come up with policies, we'll identify a problem, something that is really affecting people's lives. For example, I was mentioning the FDA before. Under the FDA, it can take a decade and $1 billion for potentially life-saving medications to make their way to market. And when you are a terminally ill patient, you don't have time to wait for that. And so what we did is we said, how can we use the powers of the states in order to help protect people's right to try to save their lives? And we did that by passing legislation in 24 states so far, 24 and counting, that says, look, if your doctor gives you a prescription, the FDA has already said this medicine is safe, they're just still testing whether or not the medicine's effective, then you have the right to go ahead and try that to try to save your life. And what we can do in the Goldwater Institute is, besides just pass policies that help people, we also have a litigation arm that can go to court and protect people's right to try these life-saving medications, for example. So it's very synergistic, and we really like that we can do all of this in-house because, as you noted, sometimes the political process just fails to protect our rights.
Well, you know, I'm glad you mentioned the variety of approaches that you have. And I think they certainly come together in a hot topic that we've decided to talk about today, and that is your efforts to ensure equal protection for Indian children. Adi, tell us a little bit about the nemesis here, the Indian Child Welfare Act that you've decided to target at Goldwater. Perhaps you could define it for us and tell us what basically its ramifications are.
Sure. The Indian Child Welfare Act was passed in 1978. It is a well-intentioned law, but still at the same time, it's profoundly flawed. And what the act does is it creates a separate and unequal and substandard treatment for children with Native American ancestry. If you compare the act with provisions that are part of state laws that are applicable in child custody proceedings, you can see the stark difference in the treatment that is given to Native American children as compared to all other children. And that really is an equal protection problem. We have had a long history of discrimination on the basis of race, and what the act does is it creates a separate treatment and treats Native American children differently based solely on their race.
Adi, the tragedy of this here is that many people promoted the Indian Child Welfare Act under different auspices, that it was something that would empower Indian children. It was something that was good for them. And as it turns out, that's really a ruse. Christina, what are some of the negative effects that we have seen, that you have seen, with regard to the Indian Child Welfare Act?
Well, imagine for a moment that you have a child who's been abused or been neglected, and so has to be unfortunately taken from her home. Well, typically she'd be taken from her home and be put into the foster system or made available for adoption. What a state judge would do in a situation like that is consider the child's best interest in giving that child a new home. But unfortunately, the Indian Child Welfare Act, believe it or not, says that the judge can't consider the child's best interest in making that assessment if that child has Native American heritage. So if the child has Native American heritage, then she has to be sent to a home, given preference to be sent to a home to live with Native Americans, regardless of whether or not that is in that child's best interest. And so unfortunately, we've seen children who have grown up for years with loving foster families who have been ripped from those homes, taken away from the only families that they've ever known, and sent to live with families that did not want them and are not well equipped to deal with children, sometimes families that have known histories of abuse. And we've seen those children live horrible lives. Sometimes they've even died. They've even been killed. And it's very, very sad, and it's very detrimental to these children and, frankly, to the Indian tribes.
Now, you're not just speaking theoretically about what the harms could be. You actually have tracked these, and you've collected case studies, which are actually stories, tragic stories. Adi, tell me a little bit about that. I have to tell you, I appreciate the fact that you've put many of these stories up on a website, and you may want to tell our viewers how to access that website. They're absolutely heartbreaking, and what makes it worse, of course, is that the power of the state, the power of the law is turned against the welfare of these children. Adi?
Absolutely. You can go and check out our stories on equalprotection.org. And coming directly to your question, one of the most heartbreaking cases that comes to mind is the story of this little girl, Lauren Whiteshield. She was taken away from her biological parents because they were abusive and neglectful towards her and her twin sister. She was living in a loving foster home for almost more than a year. And then, because of the Indian Child Welfare Act, she was taken from the loving foster family and placed with her grandparents on the reservation. A month later, authorities found Lauren Whiteshield dead because she was thrown down an embankment by a grandmother who had who had medical problems, psychological problems, and one day she just decided to throw this girl down an embankment and then bathed her, put her to sleep. Unfortunately for Lauren, she never woke up.
That is just absolutely tragic. And Christina, I just want to ask you, my mind is baffled, really, that we allow such a thing to happen. And we do so under the guise of advancing the welfare of Native Americans. But how does it happen that we end up with two kinds of legal jurisdictions, two kinds of laws, so to speak, in the same country? And what is it that permitted this to take place?
Well, as you and Adi have alluded to, this is the law, a case of good intentions gone horribly wrong. Back in the 70s, Congress decided that it was important to look out for tribal interests. And of course, promoting history, promoting culture, those are not bad things. But unfortunately, what happened is we've created, as Adia said, a separate and inherently unequal system. And what we've done is we've put group interests ahead of the rights of individuals. We've said that the best interest of individuals is going to be not considered, and instead we're going to look toward the importance of groups. And that is something that our Constitution just does not allow for. That's something that our country has a rich history of fighting to be race blind. Every child deserves equal protection under the law. The law is supposed to be colorblind, and the law is supposed to look to children's best interests regardless of their race, regardless of their ethnicity.
One of the things that we share in our beliefs in our think tank world in the State Policy Network is that rights are individual, that liberties are individual, that we are not first and foremost defined as being members of a flock or a herd or a tribe, but the Constitution stands for individual liberties. Adi, is this what has been trampled under by the Indian Child Welfare Act?
I think one of the biggest things that the Indian Child Welfare Act completely disregards is that every child deserves an individualized determination in a child custody proceeding. Every child deserves equal treatment under the law. And once you start making distinctions based solely on the race, what you're really saying is you're stereotyping racial conformity. So what the Act really requires of American children is to create racially conforming relationships under the law. And there's no other law in the country that requires people or forces people to conform to racial norms or racial stereotypes. And that is really a profoundly flawed aspect of the act.
It seems as though this has been quite counterproductive then, that advocates of the Indian Child Welfare Act had attempted to promote ostensibly the rights of a group, the rights of a people, but ultimately have damaged the true rights of individuals as ensured by the Constitution. We're going to talk a little bit more to our representatives from the Goldwater Institute, who are doing just some fine work on behalf of the children whose work, who will be affected by their work, as well as on behalf of our legal system, our constitutional system of rights. We'll be right back in a short break. Don't go away, and we'll conclude today's Hana Kakou talking about equal protection for Indian children.
Mahalo for watching ThinkTech Hawaii. We are a channel dedicated to raising public awareness about the importance of technology, energy, diversification, and globalism to the future of Hawaii. We broadcast and stream daily from 1 to 5 every weekday, and we broadcast on Olelo 54 and OC16 TV. All of our shows are archived on thinktechhawaii.com, and we hope to see you there. Aloha.
Hi, I'm Ethan Allen. I'm the host of Likeable Science on ThinkTech Hawaii. We talk about why people should like science, why science is actually fun, how science is a dynamic and vital part of everyone's life, why everyone, every man, woman, and child on the planet should really know science, should love science, should be familiar with science. So it's a great show. People come on here and have interesting conversations with us. They tell us why they do what they do, why they love it, why we should love it too. I hope you'll join us every Friday, 1 to 2 p.m. And of course, you can see it anytime on YouTube. Aloha.
Aloha, welcome back to the final portion of our program today, in which we're discussing the Indian Child Welfare Act with our friends at the Goldwater Institute. As you've been listening, no doubt you have seen some parallels for those of you who are aware of the situation in Hawaii, in which there has been a movement to define the Native Hawaiian people as Aboriginal or indigenous peoples who are a tribe in the sense of Native American Indians. You know that at the Grassroots Institute, we have stood for the individual rights of Native Hawaiians, as well as all people, simply on the basis of being worthy of equal treatment under the law. And this concept of tribalism has many, many facets to it that are actually designed to work against the individual. Christina, we're back with Christina Sandefur, Vice President of the Goldwater Institute, Vice President for Policy, and also an attorney. You were pointing out to me in the break how deceptively non-representative the Indian Child Welfare Act is, and how really tyrannical the hold it has over people should they have even just one drop of blood and be identified with the tribe.
That's right. You know, in America, one of the wonderful things about being an American is you sort of get to invent yourself, and you get to identify with groups that you choose of your own free will to identify with. But under the Indian Child Welfare Act, the tribes can decide whether or not you are considered a member of their group. The individual gets no say. The birth parents of these children do not even get a say. If the tribe decides that you are Native American, even if you only have, as you said, a drop of Native American blood, even if you have had you've never lived on a reservation, you've had no contacts with the reservation or that way of life, nevertheless, the Indian Child Welfare Act allows the tribe to deem you an Indian child and to take you away from a loving home. That is just uncalled for, that's unacceptable in America, and frankly, it's both unconstitutional and immoral.
So you are saying literally that a child is in a position of having the rights of being an American citizen under the Constitution completely nullified. She cannot claim, I am an American, I have this right based upon the Constitution, and the tribe itself is the source of power and jurisdiction over her. Is that what we're hearing, Adi?
Yes, that is absolutely right. we hear many stories of children who are placed in unsafe homes because of the Indian Child Welfare Act. And the only reason why that happens is because the child has a drop of Indian blood. One of the most important cases in this area, the baby Veronica case that went up to the Supreme Court, baby Veronica there had 1.2% Indian blood. Her closest Native American ancestor was in the times of George Washington. And the Indian Child Welfare Act was fully applicable to her as it would be to a full-blooded Native American. So the question went up to the Supreme Court. The Supreme Court decided to avoid the constitutional issues presented in that case because there was this narrow question of whether the birth father gets custody of the child. But what the case really highlights, the baby Veronica case, is that the basic premise under the Act needs to be questioned and needs to be questioned seriously. Do we require children to sever existing relationships in order to create new racially conforming ones? That's the question really under the Indian Child Welfare Act, and in the lawsuit that we have filed, I think the court would have to confront it upfront.
This is such a strange irony because many of the advocates of racial identification, especially on the basis of blood or a particular blood quantum, promote that because they seek privileges, because they seek the guarantee of certain rights. But what you're pointing out is that that's a double-edged sword, that this definition by racial blood quantum is actually something that can result in the loss of rights. Is that what I'm hearing, Christina?
Absolutely. You know, in America, we don't define rights by groups. We say that individuals have rights. And unfortunately, under the Indian Child Welfare Act, it really flips that notion on its head. And it says, look, the individual rights do not exist. Individual protections do not exist. Children will be treated differently based on their race if a group decides that that's how it should be. That just flies in the face of our entire history. We have fought in this country, we fought many wars in this country in order to have an equal set of laws, in order to ensure that everyone would be treated equally under the law. And so this really is just a huge step backwards, and unfortunately there are lives at risk.
Adi, as you take a look at what's going on here, and I know, I've talked with you and Christina, your hearts are for justice, and they're also filled with compassion. But are you ever accused, though, of being against the Native American Indian people, of actually somehow trying to oppose what they have accomplished?
I think not, because we really have no lawsuit against the Indian tribes. Our lawsuit does not affect the jurisdiction or the authority of the tribes and the tribal courts to deal with matters that are properly before such courts. All that we are asking is for state courts and state agencies to provide equal treatment to all children and adults involved in their care. That, I think, is the basic distinction under the Indian Child Welfare Act. We are not saying that, tribal courts or tribal authorities cannot deal with child custody cases or proceedings. They totally can under their tribal constitutions, under their tribal laws, and they can apply those laws for children who are born on the reservation, who live on the reservation. They can apply those laws to parents who live on the reservation. Mm. But when a child and when adults don't live on the reservation, they don't follow any racially conforming or culturally conforming norms, they live in the state, then it is unconstitutional to apply to them this separate and unequal treatment. Mm.
Perhaps you have a word for us here in Hawaii as we're dealing with a situation. I'm part Native Hawaiian, and so I'm very involved in a movement that is attempting to identified the Native Hawaiians as a tribe. But there's a problem, and it's a very basic problem. Native Hawaiians never were a tribe by the definition used by Congress or by the Civil Rights Commission. Two of the criteria right at the front end are that a tribe is racially defined, and secondly, that there's a continuing form of governance. Neither of these is true of the Native Hawaiian people. We never defined ourselves, even under the Hawaiian Kingdom, on the basis of race. We were totally racially inclusive, and there is no continuing form of government. Yet there is a movement of people who think that becoming recognized as a Native American tribe would be the answer to many of the problems, social problems, advancement problems in terms of housing, education, jobs, and so forth. Christina, would you have any cautions or any insights, if you will, for those who seek tribalism as a pathway for the advancement of Native Hawaiians?
Well, absolutely. First of all, I'll say that, to me, that just seems so contrary to the aloha spirit that really pervades Hawaii. That's the Hawaii that I know. I have family in Hawaii, and as you've said, it's always been such an inclusive environment. And so people in America should be free to associate as they would prefer and as they'd like, and really build their own identities. But I would caution those who do want to create some sort of government-forced group and government-forced race-based association, and that is that, well, one, please look at the lessons that we are learning, the hard lessons that we're learning from the Indian Child Welfare Act, but also any time that you look to government for special favors, there are always adverse consequences, not just those that we're seeing in the Indian Child Welfare Act, but of course, any time that you take the government's assistance, you now have the government, the federal government, being able to tell you what to do, to place all sorts of restrictions. You mentioned at the beginning of the show that that the state of Hawaii and many states are in a situation where they are trying to get more and more federal funding. And I would caution those states to think carefully about those decisions, because with more federal funding comes more responsibilities and subjects your citizens to the federal government, which may not always be a good thing.
Thank you. And I think we need to take that into consideration. Adi, what is your opinion on how applicable the Indian Child Welfare Act would be to Native Hawaiians if they are recognized by the Department of Interior as a Native American Indian tribe? Would we need to be concerned about the Indian Child Welfare Act and other such legislation?
Oh my gosh, yes, absolutely. I mean, if the federal government defines a Native Hawaiian within the definition of a Native American under the Indian Child Welfare Act, then the act is applicable to Native Hawaiian children as much as it is to Native American children. And we have seen all the horrible consequences of that of the application of that act, and it would be horrifying. I think Hawaii should take this as a cautionary tale.
Just very quickly, we've only got a couple of minutes. Back to you again, Adi. What are some of those other kinds of consequences, other laws that may prevail upon Hawaiians if they're defined as a federally recognized Indian tribe?
There are property laws that become applicable under federal Indian law. There are many criminal laws and criminal jurisdiction of the federal government that kind of encroaches upon the traditional state concerns like domestic relations, crimes. All of those become federal issues if Native Hawaiians are defined as Indian tribes.
You know, it's almost as if the movement to to recognize Hawaiians as Native American Indian tribe lacks a certain amount of disclosure, the kind of disclosure you get with the prospectus for a financial program or something, really showing you what the consequences may be. I've enjoyed listening to both of you. You've given us a lot of insights. Any last word before we go, Christina?
Well, I would just say that if your viewers are interested in learning more about our efforts in the Indian Child Welfare Act, they can visit equalprotection.org. And if they're interested in other ways that we are fighting for freedom coast to coast, they can visit goldwaterinstitute.org online. And we thank you very much for having us today.
Well, it's been delightful talking to you, Christina, and to you, Adi. Any last word?
I say mahalo.
That's a great word. And we want to share with you not only mahalo, but the aloha spirit. My guests today, Christina Sandefur and Adi Dynar of the Goldwater Institute, fighting to preserve America's freedoms, individual liberty, and the protection of all, including Native American children, Indian children. I thank you for being with us today on ThinkTech Hawaii's Hana Kakou. We'll be back again next week. Until then, aloha.